If you're an attorney in the state of California, you need to know about this new law. So today we're going to be talking about Senate Bill 235, which is a big change to the way discovery is done in the state of California. So what is Senate Bill 235? And we're going to shorten that, just call it SB 235. So what does this bill do? SB 235 amends current discovery law, and what it does is that it institutes a procedure for initial disclosures at the state court level. It's very much like what federal court already does with some changes. A quick summary about what SB 235 does. 3 main points. 1, it amends California Code of Civil Procedure 2016.090 and imposes new discovery obligations requiring parties to make initial witness and document disclosures within 60 days of another party's request. 2, it amends current law and requires that courts impose a $1,000 sanction on any parties that fail to act in good faith or comply with the new statute. And lastly, it applies to all cases filed on or after January 1st, 2024. And it has a sunset date, or meaning that it goes up until January 1st, 2027. And so what does that tell us? Well, the legislature is trying to see whether this is going to work at the state court level. And if it does, we'll likely see that it becomes permanent law in California. And if it doesn't, we'll see what other changes they make to it. So first, I want to start off with what types of actions are excluded. Where do these initial disclosure requirements not apply? And there's 6 types of cases where these initial disclosure laws do not apply. They don't apply to unlawful detainers. They don't apply to small claims. They don't apply to an action under family code or under the probate code. They don't apply in an action where a party has been granted preference under CCP Section 36. And it does not apply with any situation or in any action where a party is not represented by counsel. How is this new law triggered? How are these initial disclosures triggered? Believe it or not, initial disclosures actually exist already in state court and have existed for a while. But the current law, or rather the old law, because we're already in 2024, the old law authorized the court, with the stipulation of the parties, to enter an order where the parties had to provide initial disclosures within 45 days of the court's order. The new law that went into effect January 1st, 2024, requires that each party that has appeared in a civil action provide initial disclosures within 60 days of a demand by any party to the action, unless the parties otherwise stipulate. The key takeaway here is that its stipulation is not necessary anymore. All that's required is for one party to make the demand, and as long as one party makes the demand, we are now in initial disclosure land. So, what are the type of information or documents that each party has produced? And for the sake of our discussion here, what I'm going to do is I'm going to talk about as if we were the party disclosing the information. But of course, that also applies to the other side who's going to have to disclose the information to your side. All right, so we're going to start off with what to produce. There are 3 main categories, information, documents that you have to produce: witnesses, documents, and insurance policies. Let's talk about that first one. Witnesses. The new law requires that you produce the names, addresses, telephone numbers, email addresses of all persons likely to have discoverable information, along with the subjects of that information that the disclosing party may use to support its claims or defenses, or that is relevant to the subject matter of the action or the order on any motion made in that action. So it's actually a little bit more expansive than what is already in federal court. It's not just information that you may use in support of your claims or defenses, but it's also information that is relevant to the subject matter. So this is a little bit more expansive. You're required to produce more information than what is required in federal court. Now, the type of information that's excluded is if you're going to be using this information or these witnesses for the sole purpose of impeachment, you don't have to produce that at this stage, and you do not have to produce any expert information. The second category is documents, and the new law requires that you produce a copy or, and this is key, a description by category and location of all documents of any electronically stored information, any ESI, and tangible things that the disclosing party has in its possession, custody, or control. Again, that may be used in support of your claims or defenses, or that is relevant to the subject matter of the action. Very similar to the category of witnesses, and similarly, you do not have to produce information that is going to be used solely for the purposes of impeachment. Let's stick on those first 2 categories, witnesses and documents. What are the benefits of this new law? Well, it's going to encourage, or rather force all parties to get familiar with the case, right? You're going to have to get all your ducks in a row a lot quicker, and it's going to require the mutual exchange of critical information for both sides, and it's going going to give everybody the opportunity to start litigating this much earlier on. There's not going to be too much time wasted because it's going to force the parties to get going quicker. And listen, at the end of the day, it's going to be a great way for you to get to the other side all the information that they need to evaluate their case, and for them to get to you all the information that you need to evaluate your case, in the hopes of being able to resolve and get to resolution a lot quicker. So those are the benefits. And one final thought or tip here, as I mentioned earlier, the relevant standard here is potentially broader than federal court, and it should lead to the disclosure information of documents, whether a party intends to use it or not, because it's not just a matter of whether it's going to be used in support of your claims or defenses, it's also a matter of whether it's relevant to the subject matter. So a lot of information should be offered up, again, with the hopes of getting to resolution quicker, and that's exactly what the legislature wanted when they put this law into place. And the last category, the third category, is insurance policies. All right, and this is a big one. Rather than reading the text of the entire section of this new law, what I will point out is that it requires that insurance policies be disclosed. The law says only those provisions of an agreement that are material are required to be included. And material provisions include, but aren't limited to, any and all documents regarding whether an insurance carrier is disputing the agreements or policies coverage of the claim involved in the action. What's the point of this and the goal of this, once again, is to get to resolution quicker. For the most part, that's really going to apply to the defense side, right? Getting the insurance information over to the plaintiff side. I bet and I imagine there's going to be some discussion surrounding this particular category in particular, but it is something that the legislature intended that be produced within those 60 days of the demand. Okay, so let's talk about the standard now. Section 2016.090, subsection A2, the standard that goes into place now, says that a party shall make its initial disclosures based on the information then reasonably available to it. And a party is not excused from making its initial disclosures because it hasn't fully investigated the case, or because it challenges the sufficiency of another party's disclosures, or because another party has not made its disclosures. In other words, you have to produce the information regardless of what the other side does. That's something that you must do on behalf of your client. And really the key takeaway here with regards to the standard is that reasonably available standard. Don't get too scared or thrown off by that last portion of the text that I just read. Reasonably available is really not any different than what is already in place in normal discovery. If you go and look at CCP section 2030.220 regarding responses to interrogatories, it's the same language. Don't be thrown off. Don't be scared. You have to produce what is reasonably available to you. Now let's talk about verifications. I've actually heard many people asking questions about verifications. People have heard one thing or another. Can I do this? Can I do that? What's available to me? Is this something that I have to do? Let's dispel all the rumors and questions. With this new law, there are 3 different ways, different options to verify the responses that you produce on behalf of your client. They can be verified by the party, so by your client. They can be verified by the party's authorized representative, or it could also be verified by you, the attorney. Now, those are options. You don't have to verify for your client, but it is an option. What I will say as a caution is that if you verify the responses, you may very well be on the hook, and that could potentially lead to some issues in trial, right? There's a reason why attorneys, by and large, don't sign things as simple as proofs of service, because we don't want that to become an issue in trial where we would have to provide some sort of testimony. It is an option. You can sign on behalf of your client. We don't know the full extent of what that is or won't be. The suggestion or advice that I would say here is, as much as possible, continue to have your client verify those responses, even though it might be easy and convenient for you to sign off on them. Now, what happens if a party doesn't comply with these initial disclosure requirements? What is the method by which you can get them to comply? In all likelihood, what it's going to be is a motion to compel. We don't know what the courts are going to require, what additional barriers are going to come along with all of this, but for now, the route is likely a motion to compel, and that's exactly what the new law provides, right? It says that you can do it on court's own motion or the motion of a party to compel disclosure. All right, now we're going to talk about supplemental demands, because you may have made your initial disclosures, maybe the other side made initial disclosures, but as happens all the time, additional information comes into the hands of parties as litigation goes on. Under the new law, you do have the ability to propound supplemental requests. It is numbered though. It's twice before the initial setting of a trial, once after the initial setting of the trial, and then one more time on the party's own motion for good cause shown. So the key takeaway from all of this is that there is no continuing duty to supplement. In federal court, the parties actually have a continuing duty to supplement. Whenever new information comes to them, they have to provide that to the other side. In state court, that is not the case. In state court, you have to affirmatively serve the demand upon the other party to get that supplemental information. And lastly, we're going to talk about sanctions regarding document requests. The new law raises the mandatory sanction amount to $1,000 if a party does not comply or act in good faith with these new laws. The new law actually allows these sanctions to be imposed if the court finds that any of the following happened. A party failed to respond in good faith to the document request, a party produced the requested documents within 7 days of the hearing on a motion to compel, or if the party failed to meet and confer to resolve any dispute regarding the request. The court also has the discretion to require the sanctioned attorney to report the sanction to the state bar. So it's a lot of power and ability given to the court here. The one thing I will say is that while the courts do have this power, the court also allows the court to excuse the imposition of the sanction if it finds that the one subject to the sanction acted with substantial justification or that other circumstances make the imposition of the sanction unjust. Yes, the courts do have this additional power. However, there's a lot of discretion and leeway for a court to excuse that sanction itself. So at the end of the day, will this new initial disclosure framework work in state court? Well, I think it's going to do a great job of streamlining at least the beginning of the whole discovery process, and that's a great thing. Will it work in the long term? We'll find out and we'll see, right? It's going to go through January 1st in 2027, and whether it works, whether it's something that makes the litigation process more efficient is going to be up to plaintiff attorneys, it's going to be up to defense attorneys, it's going to be up to the whole bar and judicial system as well to make sure that this is an efficient process that works and that helps the parties arrive at resolution quicker, sooner, for the benefit of the parties. If you have any questions or want to know a little bit more information, or even if you just want the slides, feel free to DM us, email us, and we'll get the information out to you right away. I was actually part of the Consumer Attorneys of California team. I was asked to be a part of it by past President Greg Rizzio, and we were given the chance to review the drafts of the bill, provide our insights, and those insights were used in negotiations with Senator Umberg. And ultimately, the bill is what it is today, and what I'd like to do is just get out that information to you, and I hope that it helps you, your practice, and your clients.